on In-Depth Radio, NewsTalk 1010.
Live Drive.
50% of you don't have something you need to have, something you have no excuse for not having nowadays, and now there's some new software to make it really easy for you to have one. You know, a lot of people will say, well, I'm not planning to die soon, and, you know, they say the only date you don't get to pick yourself is the date that you're going to die, and that's true, and it's not to be morbid about it, but you just don't know when something unforeseen might happen, whether it's an illness or whether it's an accident or anything else, and there are so many people that don't bother to have a will. And you say, well, I don't really have anything. Well, think about it in today's terms. I mean, if you have a house, for example, and that's all you have, with the average house in Toronto being worth $500,000, you say, well, okay, well, that's still not very much money. I just have a wife and 2 kids. Well, if you want it divided up under government rules, go ahead, don't have a will, because that's what happens. When you don't have a will, there are rules set out by the government in the law, and they decide those rules, the government, the lawyers, the legislators, how your estate gets divided up. So that $500,000 will be divided up absolutely as they see fit. So, for example, if you only had that $500,000 from your house, and you wanted all of that money to go to your spouse and not for your kids to get any of it until your spouse died so that she would have or he would have some money to live on, the government rules supersede that, and your kids would get some of it right away. So, you know, this is a kind of example, and I could give you 100. And by the way, lest you think that people like me as lawyers are lily white about all this, I hadn't redone my will in 25 years when I finally got around to starting to do it in the last year or so. And it's still not finished, you know, because until you sign it and put it away in a drawer somewhere, hopefully with your lawyer or somewhere, it's not official. I should tell you, and I'm telling you stuff that Michael Karabash could tell you better than me, but you actually can, if you haven't had a will and you think you're about to have a bad accident or something bad's happened to you, you can actually write out a will in your handwriting on a piece of paper and sign it if you don't have one. If you do have one and you write one out like that, it supersedes the will you had before. But if you don't have one and you want to write it out because you're in extremis, like you're about to have something real bad happen to you, you can do that. But the point of not having one is that it's bad news, poor planning, and Michael Karabash has done something that's meant to make it easy, just like has happened with tax returns, and that is to use the power of software to make it easier for people and, frankly, give them no excuse as to why they wouldn't have a will. Mr. Karabash, how are you doing?
I'm good, John. Thanks.
Good. So we have Will-O-Matic here, and I like the name because I think it sort of sounds like something that you could get out of a vending machine, though it's a little more serious than that. Tell us how the software works.
It's an online questionnaire. It takes you through a number of prompts and provides some information along the way. And when you're done, it generates automatically a will that you can then download, print off, and sign in front of witnesses, and you're done. You've got yourself a will.
So the questionnaire would say, you know, do you have a spouse? Do you have children? What do you own that's in part of your kind of holdings, as it were, whether that's real estate or cash or whatever?
It would ask you every type of question that me as a lawyer would ask if you were sitting in front of me.
All right. Now, I presume this is not free because, again, you've developed this not instead of having people come to your office, but you're doing it as a sort of client service to people who would like to do it this way.
That's right. The average will from a lawyer last year cost about $369. The Will-O-Matic that we're selling on our website is only $110, so it's a cost savings, but we've teamed up with some daily deal websites to offer it at a promotion of only $24, like Kijiji in Toronto or Living Deal or those types of websites.
All right, I want to ask you in a minute about the consequences of not having a will, because I'm sure you've seen that, and I sort of tried to state it in a stark way by saying it's divided, your property is divided up in accordance with government rules, but that's actually the truth. Before that, though, there's often this misconception that only old people should have a will. You know, only if you're getting up to sort of 70 years old or something, you should have one then, because the chances are something might happen to you. But there's a lot of categories of people I'm sure you would advise should have one for purposes of just sound planning.
Absolutely. Newlyweds, new families, parents, the elderly, those going in for surgery, those traveling abroad, those who have experienced the change in their financial circumstances, like you mentioned, buying a house or getting a new job, winning the lottery, and those who have experienced a change in their family status, like births, deaths, divorces, things like that. All those types of people should have a valid and up-to-date will.
Who is Will-O-Matic not good for? In other words, if you're in a certain set of circumstances, one or two things you might mention, this is, that's too complicated for Will-O-Matic.
Those with fairly complex estates involving trusts and taxes and business interests should see a lawyer. Those with international property, those who may feel that they're being unduly pressured by family and friends into getting a will or putting certain things in the will, and those who may have mental capacity issues should definitely go see a lawyer.
All right. When we come back, I want to check on traffic. I'm talking to Michael Karabash. He's a lawyer who has, done lots of wills in the ordinary way for people, but has also developed some software that lets you go online and do a will yourself, and then it prints off and you can sign it, and it costs less than having a lawyer, in most cases, do it for you. But I want to talk about this business of the government rules applying if you don't have a will, just so people understand what the consequences are, because a lot of people don't know what happens when you die intestate, as they say it, without a will. Michael Karabash is my guest. He's a Toronto lawyer. He does, among other things, wills for people, but he certainly developed some very interesting software, Will-O-Matic. Some of you have used tax filing software, and I think it came, didn't it, Michael, from one of your kids saying, why don't you do that for some other legal forms?
Yeah, actually, it was my cousin. I was sitting in his parents' house, and he was doing his taxes using TurboTax, and he said, you should do something like this for wills. And I said, genius.
Yeah, it is smart. Now, let me ask you, one of the listeners already texted us and said, have you done something that amounts to a form that you can fill in and so on for powers of attorney related to both property and personal care?
We actually sell those separately on our website. They are downloadable forms, and you can purchase them separately. Each of them sells for $17 in Ontario and Alberta. But what we're planning on doing is automating those as well across Canada within the next year.
When I was in law school, those many years ago, I think Ontario was one of those provinces where when you got married, it automatically revoked your old will. Is that still true?
Yes, unless you indicate in your will that you didn't want that to happen.
Okay, so I mean, notice to listeners that if you get married or you are getting married, if you have a will and think you've looked after yourself, that will is automatically revoked unless it has special language in it, and then you'll end up being married not knowing you didn't have a will. So that's a good thing. Now, okay, so you don't have a will. You and I both put it, I think, in some material you wrote and some material that I have talked about on the air. You are left to some government rules, which they don't give the property away to some stranger, but they certainly do divide it up in a way you might not like.
Yeah, so in a nutshell, first, if you have a spouse, your spouse will get a preferential share. Right now it's about $200,000 worth of the value of your estate.
But not everything, if that's what you wanted. If you wanted them to get everything, your spouse, and have your kids wait around until the spouse passes away, you're not going to get your wish if you die without a will.
That's right. And then after the spouse, it'll ask, if you have kids, things will get divided between the spouse and the kids. If your spouse and your kids aren't around, then it goes to your parents, then it goes to grandparents, and then cousins, nephews, nieces, and finally, if nobody's around, the government will take it.
Well, God, there's a good reason to have a will just by itself, so you can have the satisfaction of giving it to somebody else. Mm-hmm. We've got one listener here, Jean, who's got a question, and we'll try and squeeze that in before we have to go. Jean, do you have a question for Michael? Go ahead.
Yes, I do. I have two questions if I can do it quickly.
Go ahead.
My husband says if he puts on a piece of paper, I leave everything, all my worldly possessions to my wife, that will all go to me. My second question is, we have a home in our name, but he has a piece of property in his own name. Would that come to me?
All right. I know these are sometimes not as simple to answer as they might seem, but Jean asked those two questions. Michael, can you answer those?
I think I can answer the first one. Holographic wills are acceptable in certain provinces, not in others. Basically, as long as you've written the entire will.
Holographic meaning handwritten.
That's right.
In your own handwriting, and Ontario is one of the provinces that accepts them, correct?
Correct. And
right.
You don't need any witnesses, but the problem with them include, will you have thought about everything that a lawyer would have asked you about when you're doing your own will? And there's a lot of, tax-saving strategies or dispute resolution mechanisms that you may not have thought about when writing up something on a napkin.
But I guess if you go back to that case that we studied in law school where the guy was lying pinned under a tractor and I think thought he was going to die and scraped it out with a knife or something on a tractor, I mean, it's better than not having a will if you think you're about to die.
Yeah, and he wrote all to my wife. And
that's what it was. It's a true story. It's one of the cases they teach you in law school. And as for the piece of property, that you'd probably tell the person to see a lawyer about that?
Absolutely, yeah.
Yeah, because it's not clear. If the husband owns it, then he owns it, and it's not clear how it would be covered by the estate. We might have to do a show one day where, I know it's giving away what you sell, but, where you just answer some general questions for people, because I'm sure if we opened up the phone lines, there'd be people who do that. But good on you for the software. The website address, quickly?
DynamicLawyers.com.
DynamicLawyers.com. We'll put that up at NewsTalk1010.com so people can find it. And, I think that's making it easier for people and making the law a little less unfriendly, so good for you.
Thanks, John.
Michael Karabash, who is a lawyer and has developed the Will-O-Matic software. You might want to take a look at that website.